I would like to reserve 3 minutes of my time for rebuttal. This is a case where there was a failure to join an indispensable party pursuant to Rule 19, which ultimately led to an erroneous dismissal of Mr. Kuo's case for failure to prosecute. The indispensable party, non-party, who is not joined is Mr. Kuo's wife. Her last name is Jing, not Kuo. The disputed issue is in regard to a settlement term sheet. And defense counsel has stated in its brief that the Belfiglio defendants would not have signed the settlement term sheet were it not for the indemnity provision contained in that settlement term sheet. The indemnity provision that was referenced subjected both Mr. Kuo and Ms. Jing to indemnity liability if there was a landslide that transported fill dirt from the property where they lived to the Belfiglio's property. The Belfiglios, in their brief, also argued at the same time that, and persuasively, that Ms. Jing, it was not a property owner, that the property was titled only in the name of Mr. Kuo, and not surprisingly, Ms. Jing was not willing to sign the settlement term sheet. There is in the record an affidavit from Ms. Jing in which she states that she was not a party to the proceeding, which is unquestionably true, that she was not represented, and that she was forced to sign the settlement term sheet by Mr. Kuo's attorney. And there is some teeth to what she has to say in her affidavit. There's two pieces of statements in the record from Mr. Kuo's attorney at the time.
Counsel, can I ask you a question in relation to this? Ultimately, this case goes out on a dismissal connected to failure to prosecute, right?
Correct.
Given that ultimately this case is not resolved on the basis of the settlement agreement, enforcement of a settlement agreement, and instead just on the basis of failure to prosecute, does the indispensable party argument really matter, given that that's the basis upon which this case? I mean, I get it in terms of if we were here, there was a motion to compel or a motion to enforce the settlement and action was taken up. But since we're here on the dismissal for failure to prosecute, why does any of that? And the discussion is all related to the settlement, right? And the settlement largely becomes irrelevant if that's the basis of dismissal, doesn't it?
No.
Okay, why not?
Because Mr. Kuo filed a motion to fix the settlement term sheet. And while Mr. Kuo's suggested remedy was procedurally improper, the point he made to the trial court was that his wife was not a party to the transaction. And that should have been a red light to the trial court and to the defense lawyers who had law degrees that what you need to do at that point is stop the proceedings, and somebody needs to have process issued for Ms. Jing to have her brought in. Proceeding at that junction without bringing Ms. Jing in as a party was acting without jurisdiction. So you're right, it's a two-part argument here. But the first part is, as soon as Mr. Kuo brings to the attention of the court, which he should have, and we cite the case of Baker versus Foster in our brief, at that point, somebody said, including the trial court, said, hold the phone, we need to bring Ms. Jing in here. If she's served with process, the court obtains jurisdiction. Acting without jurisdiction was improper.
How are her rights in any way being adjudicated with a dismissal of Mr. Kuo's action? And it's how are her rights being implicated in that decision in terms of the ultimate basis? I can follow you on this if we're enforcing a settlement, but I'm still at a loss in terms of what's the implication here for her in terms of his action being dismissed for failure to prosecute.
Well, under Rule 19, the standard is if complete relief cannot be accorded to all the parties, then Rule 19 says that summons shall issue. And while I grant Your Honor's point that Ms. Jing, who clearly did not want to be an indemnitor to this proceeding, is not harmed when her husband's case for money damages is dismissed for failure to prosecute, the larger point is Rule 19 is greater than that, broader than that, because it's not just focusing on the rights to the non-party, but also it looks at can complete justice be rendered to the parties who are in the lawsuit if that party isn't joined. And from Mr. Kuo's perspective, certainly, at that point and continuing it thereafter, Ms. Jing needed to be in that lawsuit. And in fact, there's evidence in this record where he reaches out to defense counsel for Metro and gives defense Metro's counsels his wife's email address. Mr. Kuo is saying, I don't represent her. You talk to her. I don't have the authority to speak for her. And the trial court just blows by all of that. And it all could have been avoided. There could have been complete relief for all of the parties if Ms. Jing had been joined. This is not a buyer's remorse case. Mr. Kuo filed a motion to enforce, which specifically subjected Ms. Jing to liability. And what happens at that point is that the trial court, not Mr. Kuo, does a 180. The trial court initially, in denying Mr. Kuo's motion to fix, took the position that the settlement sheet was a complete agreement. She blew past the point that Ms. Jing was not a party. She treated her as a party, saying, including Mr. Kuo's wife, and she proceeds that the court cannot and will not change it.
I want to touch upon your third argument here, the third issue you've raised some too. We've talked about indispensable a fair amount, but you raise a concern with regard to the attorney's fee award in this case, and you note that the trial court did not reference or cite a statutory basis for the award of attorney's fees in this case. In terms of, let's assume you're right, that there's legal error, that there's error in failure to do so. Is the appropriate response a remand in that circumstance for the trial court to identify the basis of the attorney fee award? And why isn't that the appropriate way? If you're right on that question, is the right way to handle it a remand?
Well, the basis for the award is there's not a legal basis stated in the court's order or in the motion requesting attorney's fee, but the underlying support for that is the grant of the failure to prosecute and that motion to dismiss. So if the case is remanded and the remedy we're requesting is that the case be the dismissal be reversed.
For purpose of argument here, let's assume that we disagree with you on indispensable party, we disagree with you on failure to prosecute, and we're looking at the attorney's fees question. I'm not saying that that's where anybody's at, but let's just say that's the scenario we're looking at. Does the attorney's fees question, and you're raising the issue that there's no authority cited and there's no authority referenced in the motion, does this need to go back for remand for the trial court to indicate what the basis of that ruling was? And if we agree with you on failure to prosecute, that puts it in a whole different cast, but let's assume for purpose of argument that we disagree with you on that point. Does it still need to go back for the attorney's fees for the trial court to indicate what the statutory basis is?
I understand the court's point and the way the question is phrased. I would say no. I would say that it is if the case is closed at that juncture, there was a failure to state the grounds to support it, and the plaintiff had his chance, the Belfiglios had a chance, and I would say that that is not on the table. Of course, as I think Your Honor proceeds.
And you would connect that with the brief not stating a statutory basis also, in addition to the fact that the order didn't state it, that the brief didn't identify a statutory basis for the attorney's fees.
Correct.
Okay.
Correct. So the point here is, in terms of the dismissal for failure to prosecute, what we had here is, after the court states that the court cannot and will not change the terms of the settlement term sheet, and she holds the motion to dismiss in abeyance to give the parties an opportunity to file a motion to enforce. Mr. Quo does that. He complies with what the court was expecting him to do, and his proposed settlement release agreement, as I stated, includes subjecting Ms. Jang to indemnity liability as requested. The court, not Mr. Quo, then takes a 180 and states, look, I cannot enforce this agreement, and Mr. Quo is avoiding putting his case up for a trial on the merits when he was simply trying to do what he reasonably understood that the court wanted him to do. And then she proceeds, as Your Honor has noted, not only to dismiss the case, but award $10,000 in totally unsubstantiated or groundless claim for attorney's fees. We submit that under the Discover Bank versus Morgan case, that action on the part of the court was illogical. It took an erroneous view of record evidence and constituted an injustice to Mr. Quo. We ask that this case be reversed and remanded with instructions that Ms. Jang be brought in as a party. Thank you.
Thank you.
Please the court. Grover Collins on behalf of the Belfiglios and of the Nashville Bar. I think the court, just listening to the questions that were posed, I think the court has kind of at least gotten to where I was having trouble with this case as well when it was first appealed. And I think that question is sometimes, when you, as Mr. Winter effectively argued in his brief, sometimes you can get lost in the trees and fail to look at the forest. And I think as we look at Rule 19, I think the court has asked the questions that I had for myself, and I think that I don't think there's a logical basis for that Ms. Jang or Ms. Guo to be an indispensable party, and I think that's been fleshed out in our brief, and I'll rely on that unless the court has any specific questions about that. Based on the questions posed to the appellant, I want to address specifically, I think in page 22 of our brief, we did cite a statutory basis for attorney's fees.
Was there any, I may have missed it, but I didn't see any citation below to the trial court in terms of a statutory basis for attorney's fees, and I didn't see any citation in the court's order for a statutory basis for attorney's fees. So it looks like the first time that we may have a statutory basis referenced is on appeal. And so given that, I asked the question whether it should be remanded. Opposing counsel says essentially it's too late. Why is opposing? I'm assuming you take the view that that's wrong. Maybe you don't. Maybe you agree that it's too late. But is it too late and for that? Well,
we would certainly take the position of whatever gets us our attorney's fees is the right answer. But I guess the point is, if the court needs a statutory basis in order to award attorney's fees, and that be stated by the trial court, then I think it can remand for the specific purpose of we need to make a specific findings as to why and the statutory basis. I think if you look at the record, specifically on page 1041, and that's also cited on page 9 of the reply, the trial court said, the court found that the trial court said, throughout the proceedings, consistently reflected no intentions of pursuing the claims outlined in complaint. Instead, it is clear that his actions were solely intended to prolong the resolution process. And I think being there, that was the reason the court made the decision that they did, was because they felt that Mr. Quo had no intentions and was seeking only to prolong, and that was the reason for the punitive nature of the attorney's fees. And the fact that when we had to file that motion to dismiss. But I had a fairly long argument about what we were going to talk about as it relates to Rule 19, but based on the court's questions, I don't feel that's
let's talk a
necessary.
little bit about the indispensable party in terms of, is here, you have a process in which there ends up being a settlement or not a settlement, or a settlement sheet or agreement and unsigned. In terms of where the trial court ultimately decided this case, which was failure to prosecute, I'm just going to dismiss, I'm not going to do anything with the settlement. And is that a fair characterization of what happened in the end of this case? That the trial judge essentially treated the settlement as, look, you guys have been talking about a settlement, there was some discussion about enforcing a settlement, but I'm not going to do a thing with the settlement. Instead, I'm just dismissing this case as failure to, on the basis of failure to prosecute.
I think if you look at the record on page 1050, the trial court said, while the term sheet is a contract, the fact that the final settlement agreement and release has not been memorialized as contemplated and required by that contract, the court cannot enforce it. It's impossible to enforce and require the parties to agree on something that they're not in agreement on. Therefore, Guo's motion to enforce the settlement sheet is denied. That was her speaking from the bench. So to your point, I think she effectively ruled, I'm not even dealing with the settlement agreement. I'm not dealing with the term sheet. I'm not dealing with that at all.
And Ms. Jang's rights aren't implicated by the dismissal for failure to prosecute, and she didn't bring the action. She's not, so her rights aren't implicated in terms of the basis of decision in this case.
And that's been our position, or that's been my understanding from the beginning, and that's also why we mentioned in our reply, well, Ms. Jang has never asserted that she had a right. She's never filed a motion with the court. She's never said anything, hey, I need to be a part of this lawsuit. Counsel feels like that's immaterial, but I simply don't. If she felt like she had reason, then she certainly knew and was on notice. You know, when we talk about
She hasn't had an action dismissed.
right.
So, okay.
And the cases that were cited, much like specifically the Baker case, I mean, this is an adjoining landowner that has no idea what's going on. This is not somebody that, I mean, Rule 19 is to put people on notice that, hey, if something's going on and your rights could be affected and you don't know about it, the court needs to do its job and put everybody in the kitty, and we all have a resolution of this. That's not what was going on here. What was going on here is the fact that Ms. Jang knew, she was aware, she had proper notice, and she simply sat on her haunches and failed to, you know, bring any sort of action whatsoever. And that's just not what Rule 19, in my opinion, should be used for. And I don't think that's what's been used for classically into the current jurisprudence. So that would be, we simply don't think there's the argument has merit as it relates to Rule 19. And if the court has any other concerns as it relates to the attorney's fees, I'm happy to attempt to address those if we haven't already. With that, we would just simply ask that this appeal be dismissed and taxed to the appellant. Thank you.
I would like to cite the court to the Baker versus Foster that the council has been discussing today. And it states as follows for Tennessee Rule of Civil Procedure 19.01, quote, the rule, quote, is designed to protect the interests of absent persons as well as those already before the court from multiple litigation and inconsistent judicial determinations. Citing Citizens Real Estate and Loan Company versus Mountain States Development Corp., 633 Southwest 2nd, 763, as well as Wright and Miller. What you have here, as I stated earlier, is that it's not just the interests of Ms. Jang that are at stake here. And the fact that she didn't move to be joined is immaterial. Mr. Quo certainly had interests that were at stake here and were compromised due to the trial court's failure to apply Rule 19.01. And defense counsel has cited the trial court's
How were his
finding.
interests negatively implicated with regard to the dismissal on the basis of failure to prosecute?
I'm sorry, I've missed.
How was his interest adversely affected with the dismissal on the basis of failure to prosecute by failing to join Ms. Jang?
Well, then there would have been a trial on the merits. There would have been a trial on the merits. There would not have been there would have been no grounds for a motion to dismiss for failure to prosecute, and whatever happened, happened. But at least Mr. Quo would have been able to have had a trial on the merits, and he didn't have his day of court because the trial court was wrong in not applying Rule 19 in this case. And the trial court was also wrong in its holding that the contract couldn't been enforced. It could have if there had been appropriate findings were made, but the trial court didn't tackle that and instead decided that Mr. Quo was acting in bad faith simply to prolong proceedings.
Mr. Quo hasn't brought an action, though, to enforce the contract, right? I mean, that's not Mr. Quo has not brought an action to enforce the contract, has he? I mean, this is arising in the context of this litigation rather than a separate action for enforcement of a contractual agreement.
No, he wasn't wrong, and to the contrary, he was trying to comply with the order of the court. All right. That's all I have. Thank you very much.
Thanks to all of you. And would you call the next case, please?
Piedmont Natural Gas Company, Inc. versus Blue Road